Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Well, it seems like every day now I'm doing a video about the ATF and their constant moving of the goalpost. And today, March 1st, 2022 is no different because I understand that many of you all around the country have recently received Form 1 denial letters. I want to thank a couple of our loyal viewers here, Will Longsworth and I Am Uncle Sam, who early this morning sent me some messages, kind of tipped me off to this issue, got me kind of going down this little rabbit hole and researching to figure out what's going on. So let's spend a few minutes today talking about what the hell is going on with ATF Form 1s. Okay, before we get rolling, you guys know the drill. If you like this video, go ahead and click that like button down below. If you want to stay up to date on issues related to your Second Amendment rights and all of these crazy ATF enforcement issues, go ahead and click that subscribe button. Click the little bell logo if you want to be notified when we post new videos. And most importantly, let's keep the comments and discussions coming. That's how we're going to make sure that we're getting our videos out to more lawful and responsible gun owners like yourself. For those of you who have received some of these rejection letters, I definitely want to hear about your experience down below in the comment section. Okay, so suddenly I am being contacted by a slew of people all around the country who are running into an issue where they have filled out ATF Form 1s to build a suppressor. In many instances, these people have previously done the exact same thing using very similar components to what was used in these particular builds, sent their Form 1s in, paid their tax stamps, and had them approved. Suddenly now, going through the exact same process, using almost exactly the same materials that was used before, doing everything by the book, they are suddenly being denied. What the heck is going on here? Well, I did reach out to both the field agent here in the Puget Sound region, who I work closely with, as well as I sent an email to counsel for the ATF. I have not yet received answers back, and when I do, you will be the first to know. However, I did have an opportunity to take a very careful look at the denial letter and take a look at the applicable statute, and I have a theory as to what is occurring here. Now, let's take a look at the actual denial letter, many of which you have probably received the exact same thing because I think the language is a little telling. The denial letter that I have seen reads as follows. A silencer is defined under federal law to include, in relevant part, any combination of parts designed or redesigned and intended for use in assembling or fabricating a firearm silencer or firearm muffler, and any part intended only for use in such assembly or fabrication. See the Gun Control Act at 18 U.S.C. 921 A24 and the National Firearms Act at 26 U.S.C. Section 5845. Parts that fall under the definition of silencer must comply with the registration, tax, and transfer provisions of the NFA upon review of your E-Form 1 application. The part from which you intended to make a silencer already meets the NFA's definition of silencer. The part was not registered nor transferred in compliance with the NFA, therefore your Form 1 application to make a silencer is disapproved. NFA Division notes that it is unlawful for you to possess a silencer made or transferred in violation of the NFA 26 U.S.C. Section 5861B. C. And so what you can see, and for those of you who geeked out for a while and watched the videos that we did on the solvent trap issue, what the ATF is now saying, and this is a traditional, let's move the goalpost again, let's reinterpret the law, let's provide some colorful new interpretation of pre-existing law so that we can encapsulate more individuals or more components within the restrictions of that law. And so what the ATF now is saying, and in many ways the question is, has this done away with all Form 1s? Have we essentially abolished the Form 1? Because what the ATF is saying is that any of these parts, whether they were made by Diversified Machine or somebody else, these parts standing alone, yes, an end cap, a metal tube, anything like that, these parts standing alone constitute suppressors, and therefore you needed to fill out a Form 4, not a Form 1. Now, if we take a look at the federal statute that's in question, which is 18 United States Code 921, The definition of silencer reads as follows. The terms firearm silencer and firearm muffler mean any device for silencing, muffling, or diminishing the report of a portable firearm, including any combination of parts designed or redesigned and intended for use in assembly or fabricating a firearm silencer or firearm muffler, and any part intended only for use in such assembly or fabrication. So what you can see here is what the ATF is doing is taking this little section, any combination of parts, and saying that because these parts or combinations thereof are designed in their belief that you intend to use them in a suppressor, that these parts and these parts alone constitute a suppressor, and therefore the manufacturers needed to go through all of the appropriate federal regulations and channels in order to manufacture and produce these parts for retail. And since you bought a completed suppressor, even though you might have only bought an end cap or a tube, you actually should have filled out a Form 1. Does this come as a shock? Well, not really, for two reasons. Number one, if we go back and we track the on-again, off-again relationship that the ATF has had with solvent traps, we know that this is exactly what they indicated in many of those letters sent out to those who purchased diversified machine parts. Number two, the ATF has a long history of doing exactly this, coming up with new creative interpretations. And recently, we have seen this in the last several months when it comes to interpretation of short-barreled rifles, when it comes to interpretations of machine guns, when it comes to interpretations of 80% lowers. The ATF is constantly moving the goalposts. Now, rumor is that you will be refunded your $200 tax stamp and that you can then reapply through an ATF Form 4, but that's as of March 1st, 2022, and we know since this is the ATF, we will not hold our breath. I'm sure the information will change multiple times. Listen, you may have more questions about what's going on with these Form 1s or anything related to your Second Amendment rights, and if you do, don't ever hesitate to contact us at WashingtonGunLaw.com, or of course you can call us directly at 425-765-0487. Now let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.